the construction industry. Thank you, Bill, for the kind introduction. I'm happy to be here and talk about what Massachusetts has done to give you some idea of what the state can do in terms of reacting to this issue. It's certainly not an issue that is simply in New England, even though Matt and I seem to be representing the Northeast here. This is a nationwide problem, very serious problem. Could I get my presentation queued up? Oh. Just to give you an idea about what we've done, in 2008, our governor, Patrick, within his first term, it was brought to his attention that we had this major problem with regard to what we call the underground economy and employee misclassification, and essentially, in a broad sense, misclassification of employees as independent contractors when in fact they are employees, or simply misclassification as nothing, which is, as Matt talked about, extremely prevalent as well, where people are working for an employer but are not classified as anything, aren't completely operating off the books, which is extremely advantageous for an unscrupulous employer because, as you can imagine, thank you, Bill, as you can imagine, that's pretty profitable when you don't have to pay the costs that are involved with having a workforce. So Governor Patrick created a task force with the goal of coordinating the efforts of multiple state agencies to combat fraudulent employment activities by enforcing the state's labor licensing and tax laws. And we essentially really strive to do three things: protect the rights, benefits, and wages of workers. Those are laws that are already on the books, and benefits and wages to which workers are rightly entitled. Restore competitive equality for law-abiding businesses. Businesses cannot compete. When Matt said, as he talked about in his presentation, when a business is able to cut its costs by 20, 30, 40% by cheating on their labor costs, law-abiding businesses can't compete. They simply can't. And we've heard that time and time again from employers within our state. Really, when you look at it in the construction industry, materials cost what they cost, right? There's very little room for negotiating that. Where can employers cut costs? With labor, and that's what has happened. And the third thing that we really strive to do is to pursue revenue that is rightfully owed to the Commonwealth of Massachusetts. And we don't shy away from this. Because if we don't collect that revenue, it's taxpayers and ratepayers that end up illegally, they end up subsidizing the illegal cost cutting by the unscrupulous businesses. So it's patently unfair. Our task force is chaired by my boss, Secretary Joanne Goldstein, Secretary of Labor and Workforce Development. We have approximately 13 state executive agencies that are involved, including constitutional offices of the Attorney General's office, the Secretary of the Commonwealth, and the State Treasurer, which is really unprecedented to have not only state agencies working together, but separate constitutional offices working together as well. We also have an insurance fraud bureau in Massachusetts, which is not a public entity. It's funded by the insurance industry, so it has its issues, but they are nonetheless at the table, and they have prosecuted some cases with regard to workers' compensation insurance fraud. And here's just an example. Here are the agencies that are involved, 17 agencies in total. We also have the U.S. Department of Labor involved as well. Their Wage and Hour Division and the OSHA Regional Office comes into the task force on an as-needed basis, whereby we make referrals to them and they can share information with us as well. Our efforts are focused on increasing compliance, mainly in the areas of the independent contractor misclassification law in Massachusetts. Massachusetts has a very strict test for meeting the classification of independent contractor. It's a three-pronged test. Otherwise, everyone is presumed to be an employee. All of the wage and hour laws in Massachusetts, state wage and hour laws, which encompass minimum wage, we're a prevailing wage state, overtime, child labor, record keeping, workers' comp laws, unemployment insurance laws, Massachusetts state tax laws, licensing laws, employment discrimination, and worker health and safety. Those are the areas that we primarily focus. And we do seem to spend a lot of time working on enforcement matters among businesses in the construction industry, temporary staffing services, and hospitalities and services. Although it really is in all industries, which I'll show you in a minute. Some of our successful initiatives as a task force have been in the area of investigations and enforcement, whereby we share information among the partner agencies, again, somewhat unprecedented for state government. We develop cases together and we share our resources. We also share, coordinate with each other and utilize one another's enforcement authority. So where I have authority, my Department of Labor Standards, where I have authority, for example, to enter any temporary staffing agency in the Commonwealth of Massachusetts, I can open the door for other agencies who may not have that same authority to open the door without probable cause. So by sharing information, we work together and utilize one another's authority. Not to say that we enforce one another's laws, we do not do that, but we simply work together on these issues of mutual interest. What has all this yielded? Well, revenue recovery for one, as you can see from this chart. Over the last 18 months, we have traced $21 million back to efforts of the task force. This is money in the door. This is not assessments. This is money in the door. This is Department of Revenue, Attorney General's Office, Industrial Accidents, which is our workers' compensation insurance department in Massachusetts. Unemployment and Insurance Fraud Bureau, wage restitution for workers who were robbed of wages, state taxes that were recouped, unemployment insurance, taxes, fines, and penalties. As you can see over the reporting periods, we have continued to grow in this revenue recovery. I think we're maturing as a task force, learning what works well and what doesn't. But over the last 18 months, we brought in more than we had since the start of our efforts. And we know that there is more to be had out there for sure if we had additional resources. Another successful initiative has been proactive compliance checks, which came out of the task force effort. What this entails is essentially agency licensing entities within the state proactively checking with our Department of Unemployment Assistance prior to granting a license, a credential, a credit, something where a business has come to a state agency and said, I need this, I need my liquor license, I need my temporary staffing agency license, I want to apply for this tax credit. These agencies check with the Department of Unemployment Assistance to find out if the business coming before them is, one, registered with unemployment and up to date on their quarterly tax assessments. And as you can see, we did at the bottom there 24,000 compliance checks over the 18-month period in total. $17 million was recovered for the Department of Unemployment Assistance just simply by agencies talking and checking with one another. Pretty significant, and I think shows how significant the problem is. Why do these work? Obviously, when applying for something that a business needs, they're suddenly more motivated to pay an outstanding debt that they may have otherwise ignored. It isn't as though our Department of Unemployment Assistance didn't try to collect the debts, but when employers knew that they could, as Matt said, some employers not open the mail, just not answer the phone, just completely ignore the notices that keep coming in the door saying that you are delinquent for unemployment. If they know they can go and get their liquor license tomorrow, what do they care? Their business is not being stopped. It's not being harmed really in any significant way. So when we intervened in that process and was particularly successful with our liquor licensing, boy, it's amazing when the checkbook comes out right away. How much do I owe and who do I write the check to? I think everyone would probably agree that licenses and credentials should not be given to employers who are non-compliant with employer obligations. But again, this is a somewhat novel concept. I don't know how it works in Tennessee. You might be more coordinated than we were in Massachusetts. But agencies simply did not check with each other and talk with one another. And word really is getting out that that state government it's a new day in state government, and if you're not compliant with one agency with regard to employment law or licensing, then there's a good chance that you're going to get caught. I want to talk a little bit about a successful case we had involving the Marriott Corporation. We had a big $18 million hotel renovation project in downtown Boston. We're tipped off by one of the trades unions that there was something weird going on with this major project. Out-of-state laborers and an allegation of cash payments. So we walked in with multiple agencies within our task force, and at the end of the day, uncovered over $1 million in unreported wages just on that one site. 6 companies misclassifying workers. 3 companies operating without workers' compensation insurance, major violations of the law. We also, our Attorney General's office was able to get wage restitution for the exploited workers. Indeed, there were out-of-state workers who had been transported here from a purported church in Pennsylvania who had contracted with some young men who were recovering substance abusers, many of them court involved, told that this was part of their therapy to do this physical labor, moving furniture in and out of hotel rooms as they were being renovated, forced to live in some pretty lousy conditions, to say the least, transported to and from the work site, and all for the privilege of doing this great work on this great job, paid below minimum wage in Massachusetts to the tune of $4 an hour. This story got a lot of play in the Boston Globe, which is a major newspaper in Massachusetts. Stories went on for almost a year because every time we looked at this, there was something wrong, and it was really peeling an onion. And really, you had all of the issues of the underground economy here. You had sub-minimum wages, you had cash payments, no workers' comp, misclassified employees, underreporting of payroll. It was a microcosm of all of these activities. I don't know that we'll come upon a situation like this again. I know they exist out there, but getting to them and uncovering them can be a challenge. But it really highlighted the problems with this. Another successful investigation involved Pulte Homes. Some of you may know them. They are a national developer. 5 separate subcontractors were uncovered, found to be misclassifying employees and simply not paying workers in many cases. Ultimately, over $400,000 in unpaid wages and penalties was assessed to Pulte Homes, and there was recovery as well for our unemployment insurance system. I use this example to highlight for folks what kind of numbers we're potentially talking about when we talk about this activity. I was having a conversation with our Director of Audits for our Department of Unemployment Assistance, and he just happened to mention that he had just concluded 3 audits. It took his staff 5 months. 3 audits of 3 separate companies and uncovered $11 million in unreported wages. I'm talking about 3 companies, 2,300 misclassified workers. These are huge numbers. I mean, should be a wake-up call about what kind of numbers we're talking about for what's going on. And what's interesting about this is that these were not the, quote, typical industries where we know that this activity is prevalent, where construction or restaurant industry, temporary staffing. One was an adult entertainment company, an auto auction company, and a home health care agency. So talk about running the spectrum of types of industries. Another successful initiative has been a fraud detection technology software that was purchased by our Unemployment Assistance Department. I'd say high-tech system that runs cross-matches among several different data sources fed in through different state agencies. So, for example, we have information from our workers' comp insurance agency feeding into that, licensing information feeding into that, data from the IRS. All of that runs a sophisticated algorithms and susses out fraud, good fraud cases where the Department of Unemployment Assistance gets reports where there are red flags, where data simply doesn't match up. So what an employer may be reporting to one state agency is not matching what another state agency has on record for that employer. So that's led to some has led to some excellent lead cases for our investigators, where they don't need to spend time. They know right where they're going, and they know where they're going to find problems. And just to talk a little bit in the present tense here, I just want to show folks a little bit about what's going on in terms of the complaints that are coming in. We have 3 ways that people can report information to us. We have a website, phone number obviously, email address. On our website we have a web-enabled form where people can enter complaint information or referral information and submit that, and it comes right to the Joint Task Force. These might be a little, these are probably easy to see. Most of the complaints are coming from the construction and landscaping industry. Over 50% is from construction and retail and professional services. So there's nothing scientific about this. This is simply capturing what people are reporting. But again, these are motivated by people who make an effort to contact the task force to make a referral, make a complaint, whether they be involved or have a family member involved or just know something that's going on. Interestingly, most of these complaints have multiple elements. Usually if a company does not have a workers' comp premium, that's not the only thing that they're not doing right. They're also not paying unemployment assistance, taxes, they may be underreporting their payroll. So these usually have multiple elements. But interestingly, 41% of the complaints have an allegation of cash wages being paid. 14% has an element of workers' comp issue or worker safety issue, and 13% misclassification as an independent contractor or nothing when the person believes that they are an employee. Some of the initiatives that we have underway: better education and outreach for our employer community and employees as well. Trying to maintain engagement with the worker advocacy community, business and trade associations, consumers, which is really a population that cannot be forgotten in this. Many consumers, it's all of you in this room, and all of us are consumers, may be unwittingly contributing to the underground economy by our buying choices. And we're trying to educate folks that if you are needing to have work done on your house and someone comes in and says that they can do it for 30% less than everybody else, I know it sounds like it's a really good deal, but you have to stop and wonder, why is that? And so people who want to make conscious choices about not spending their dollars, giving their hard-earned dollars to companies that are cheating not only the system, but cheating workers out of benefits and wages that are rightfully owed to them, they can make better choices, hopefully. And we also have 4 debarment lists in Massachusetts, which causes a lot of consternation among awarding authorities, and so we're working to try to deal with that. Many people report that it's just unwieldy, they're not wrong, it's just a complicated issue to try to deal with. But we are tackling that to try to deal with it. No public monies at all can be given to folks who are on the debarment list. But having checked the lists and compared that with vendor payments, I would love to tell you that that's not happening, but it is. Public dollars are being spent on folks that have been debarred for various reasons, and we need to try to work on that. Some technological improvements that we've had: an enhanced website, creation of a database, and we also are working. It's an exciting project with our Department of Revenue, which doesn't typically share any information. They are working with us on an interagency data services application, which essentially is looking to enhance data exchange processes among the Department of Revenue and all the partner agencies. We're still piloting this. There are very real obstacles to this concept with regard to legal issues, confidentiality issues, very real issues with regard to practicality of the effort, but we have some committed folks who are working to overcome some of these challenges so that we can use data for everyone's benefit. We're also in the midst of a research study. We have contracted with some academic experts from Boston University, one of whom actually was just nominated by President Obama to be the U.S. DOL Wage and Hour Administrator, Dr. David Weil from Boston University. They are working with us on a study with using our Department of Revenue tax system and unemployment assistance audits. They're combining that data and doing a study for us to measure the frequency and impact of the underground economy. It's really a follow-up to a study that was done in Massachusetts in 2004, which simply focused on the construction industry. It was a study done with Harvard University. At that time, it was a 2-year study. It looked at the early 2000s and found that at that time, at least 14% of construction employers were misclassifying workers as independent contractors. So this is a follow-up to that, not simply will it encompass the construction industry, but all industries, and we look forward to seeing what that will show us. Some future initiatives, more compliance checks with unemployment assistance. Clearly we've shown that this works. We're trying to get other state agencies to sign on with us. We're potentially looking at state lottery as a source for compliance checks. Getting our task force written into statute. That's another issue. The underpinning of our task force is an executive order, which is exactly as that sounds. The governor makes an order and says, do something. And this is what we've been working on for the past 5 years. That changes or can change with the new administration. So all of us involved know that that would be it would be a terrible shame to let all of this work go for naught if a new administration comes in and ignores the executive order. We're also looking at trying to deal with what Matt had talked about, the problem that general contractors are simply insulated from liability for the activity of subcontractors. And it's a game that goes on. These general contractors know exactly what's going on. It's why they're hiring these certain subcontractors, but the law allows them to step away from the project and throw their hands up and say, I don't know, I just had no idea that this was going on, and they can walk away from the liability. So we've got to be able to deal with that somehow. And then, of course, the study findings will guide our future actions. Some of our challenges, lest you think we have this all under control and solved, we hardly do. But we definitely have a resource challenge. There were no resources that came with this executive order. I don't have dedicated staff to it. It's simply existing investigators from all of our state agencies that do this joint task force work in addition to their other work. So that's, of course, always a challenge. Data systems are a challenge, and I'm sure they are for everybody. I talked about having the survivability of the task force. That's a problem that we're trying to work on. And another significant problem that Matt alluded to, but we have not figured out how to solve this because of the way that things are structured in Massachusetts, but the underreporting by employers of employees, not only underreporting of employees, but also being obtuse about the actual nature of the work that employees do. So it may be a construction company, or a roofing company, where that's highly risky, dangerous work, but the company may say that may have a policy that covers 3 clerical workers and not the roofers. This is a real problem for us because what it has resulted in is we're sort of a victim of our own success. Now the word is out that you better have a workers' compensation policy, and so businesses all run out and get one because it's not hard to do. But then they just get the cheapest possible policy that doesn't adequately cover everybody. That's a problem, and that's sort of like phase 2 with this. Now we have that problem to deal with, and that's a little bit, well, for us it's a lot more complex. And as Matt said, what the insurance industry seems to be doing is just simply passing on all those losses to the ratepayers. It's just not fair. I don't understand, like Matt doesn't, why this is not more of a concern in the industry, and why businesses don't rise up more against the insurance companies and say, you've got to do something because this is it's a real fraud problem. So that's what we've been up to over the past 5 years. That's what we look forward to doing, and I look forward to any questions or comments. Yes.
You had a statistic early on about $25 million that you've uncovered. Do you have a sense of potential?
We are hoping that that is part of what the study will tell us, because we don't know. And this is being done, I mean, we got that 21 million just through like using rubber bands and Band-Aids and, you know, like there's nothing sophisticated about this system that we have. It's just agencies talking and coordinating with one another, and we were able to get this money that was just on the table. And so I think that what that shows, we think what it shows, is that there's a heck of a lot more to be gained out there. And when you talk about doing 3 audits with $11 million in unreported payroll, we're talking some serious numbers, we think, of what is potentially out there in terms of revenue owed. So that's part of what we're asking the study to tell us.
Do you get to take a percentage of
No,
what you...
no, I wish. That would help fund the task force. Yes.
You mentioned that having a gateway and trying to communicate with these groups, is there a system that can be created that flags these people for their issue, these industry specific companies that are doing this, so they're like their flags so that it comes up and so that people, other companies who are hiring them, can find out if they are known for this, so to protect themselves as a company, they hire.
No, that's a really good point. And what some of the partner agencies and the task force have started doing is, in the absence of having a real technological solution that would be able to do that, and flag companies and then put that out on one big list of don't use these people. That's really complicated to do. But some of the agencies have started to publish their enforcement actions on their websites, which they weren't doing before. So they were issuing civil penalties and things before. It's just nobody really thought that anybody was particularly that interested in it. But as a result of this work, we found that perhaps it will serve as a deterrent effect because no company wants to be on that list. So better education, but that's part of our consumer education, is better education about do some research before you spend money or hire contractors or do things. Take a look at the resources that the state does have available for you to see whether these companies have had any negative dealings with state government.
The outstanding revenue that you recovered, noticing the big jumps in the recovery, was that from outstanding? Or was it fairly recent revenues? Was it from previous years or was it from current times?
Current.
And could it be from misclassification of employees by these contractors, possibly due to changing immigration laws in states like Alabama and Georgia?
The bulk of, it's a good point, but no. The bulk of those numbers and the jumps that we're seeing are admittedly largely from our unemployment assistance compliance checks and largely with our Alcoholic Beverages Control Commission. We've got 20,000 licensees, 20,000 businesses at least that have liquor licenses. And if you have a liquor license, that is likely the mainstay of your business. You will not be able to operate without it, or you'll be severely hampered. And that has been the bulk of success with those numbers in terms of having where the business has a self-interest to get the debt paid. So the bulk of those numbers is not in misclassification. There is some misclassification penalties in that, but the bulk is not that. And that's why we're looking for the next big, because now we're going to get the alcoholic beverages industry in line, right? Well, they'll be good. Now we need to find somebody else. And we think state lottery might be the next one because we certainly have tens of thousands of lottery vendors out there, and I'm not certain that all of them are compliant with unemployment. Maybe I'll be pleasantly surprised, but.
Is there any organization that works across multiple states that if a state wants to get information or set up a program, that they can go to this organization?
No, that's a great idea. states are getting into this. I've been to Washington, Connecticut, New Hampshire, Utah. It's just sort of shopping this around, like, look what you can do with not minimal effort, but not a ton of an influx of resources. I think it's just trying to get better utilization of networks out there, but I wish that they were a national organization. I don't know if you can speak to any of that now.
Us.
Yeah, the road show.
That's a role that our organization plays. If we try to connect law enforcement agencies and ideas around the country. So if I'm in Tennessee and the anti-fraud unit in Tennessee wants to know how to do stuff that they're doing in Florida, well, we know law enforcement people in Florida and we hook them up. If Massachusetts passes a good law and we're in Wyoming, and in Wyoming they're interested, that we can say, well, we probably wouldn't say Massachusetts because they probably think they're going to the Soviet Union.
Yeah, crazy.
We would say, well,
They're
look.
both not so.
Yeah, we would probably say, well, look what they're doing in Texas or Oklahoma, and copy that section. So it's really us.
Just follow up on that, is there like a newsletter or publication or guidelines that you put out that you can access?
We just have a website.
Website.
Matt, there are some states that have had, I think, semi-annual meetings of groups of states in New
Well,
England.
like for instance, there's ILSA, what does it mean?
Interstate Labor Standards Association.
That's people like Heather, they have their conferences, and this is a subject of those conferences. The National Conference of Legislatures, this was on the agenda, this issue was on the agenda recently, and they're starting to track this type of legislation.
So if I went to your website, could I get a list of all these other organizations that are doing something?
Probably not.
Why don't you put that together for us? Wouldn't that be a real valuable thing? It would help you, but it would help a lot of other states to kind of, they're starting from scratch. I don't know how many states there are starting from scratch, but have a bunch. And, this is obviously extremely complex to kind of think about how you go at this thing and prioritize things. So it would be nice to have a little guide book.
We're working on it.
We're working on it?
We are. Indeed we are. Another organization that's got involved is the Columbia School of Law Attorney General's program. They have a website on this, and they have source material also from other states. Another point I wanted to make, you saw that list of states we put up there, There's some places that are conservative states, like Tennessee and Texas have gotten involved in this, so we're starting to get to a tipping point where, and Texas is serious about it, and they're not just going to, they approve the law, they're going to use it. In Tennessee, they approve the law, and they're going to use it. So we're reaching a tipping point. So, for instance, when I'm in Wyoming, and then someone from the state National Federation of Independent Businesses pops up and says, this is the Obama administration trying to destroy, the anti-business Obama administration trying to destroy individual entrepreneurship. That argument starts to look a lot less credible when you have Governor Perry signing these bills, Governor Jindal signing these bills, Utah, I've seen this legislation, and isolating Oklahoma, the governor in Oklahoma signing this legislation. All that stuff is starting to fall apart. But yeah, more needs to be done for the states that are just starting out to reach out and find a library of things to do, ways to go. I know for a while you all had this discussion group that was led by Jennifer Moran, where task forces from mostly the Northeast would talk about what they're doing in their cases. They have monthly phone calls or bi-monthly phone calls. But I think that's probably hasn't been happening since Jennifer went to
Right,
the deal.
why don't you do us a favor, give us a 2-page document with all these websites you're referring to. We have a hard time finding on our own, you know them. And send it to Bill, he'll send it out to Carol.
Sure.
Can I just have one more question? I know the Department of Labor person is not here. What role is the U.S. Department of Labor playing in encouraging states to go after these strategies? It just sounds like that be such a good strategy in some of these states that are paranoid about the federal government. But is there something they're doing that?
Yeah, the U.S. Department of Labor Wage and Hour Division was criticized in a 2009 GAO report for silo enforcement within its organization between them and the IRS, and recommended MOUs between them and the IRS to get to work on joint cases of egregious violators, break down silos within the Department of Labor, and to sign MOUs and do joint investigation work with the states. And that's being executed right now. They've hired 300 additional investigators, and they are starting to track themselves as classification issues. Now, they were in support of federal legislation that would have created a penalty for failing to properly classify someone as an employee, like they have in Massachusetts. But as you can guess, that didn't get anywhere in U.S. Congress. The IRS, the last IRS study on this problem was done in 1984. They're doing a study right now. They're wrapping up audits of 6,000 employers, and they're going to produce new data on the level of this problem.
I have a comment and a question, and the comment is that given what you've said in this session and what we heard this morning from John and in the prior session, right, you can see here that the fundamental issue is this a state problem or is this a national problem? Because if it's a state problem, then the states compete against each other, and as John suggested, it may be a race to the bottom. So if you think, for example, about Social Security as an example, would we want Social Security to be run as a state-by-state system? I don't think so. So apart from the specifics of any of the enforcement matters that are being discussed, this issue of what should remain with the states and what should be a federal responsibility with uniform standards is, I think, an absolutely key question. It's the same question that is applied to voting, and it's the same question that it's applied to having each state issue its own driver's licenses versus having a national one like most countries do. The question I have for you, and I suppose it's most for you, Heather, is in some parts of the country, managerial misclassification, especially in retail, store managers who claim they're not really managers, they're employees, and thus they should be reclassified and paid overtime work, and sales personnel who in some recent cases, in pharmaceuticals for example, have been ruled to be non-exempt from the FLSA. Do you find those kinds of cases in Massachusetts, or for that matter in Tennessee?
We do. We do find those, certainly. However, just given resources, we don't, and let me preface this by saying our Attorney General's office enforces the misclassification law and they enforce the wage laws. So I don't work for the Attorney General's office, I can't speak for them, but they are a partner agency and we do discuss various cases. Generally, there is not a lot of focus on those individual cases. However, if there is a business that we uncover that is systematically doing this, then the Attorney General's office will pursue it. But we certainly do get complaints from individuals who call in and say, you know, I'm a manager, a supervisor, but told I can't get overtime. And we do advise them of their rights and try to help them. But we see just such more egregious issues going on where we've got sub-minimum wage, we've got people who have been injured on the job and dumped at a hospital with, you know, and told you don't know who you work for, you know, you've never seen us. Just so the problem is huge and it's vast. I mean, it runs the spectrum from the most extreme example of, you know, essentially borderline human trafficking and all that comes with that to the supervisor who may be told that by his employer that he can't collect overtime because he's exempt or maybe misclassified as an independent contractor. So yes, it's all there.
This is sort of related perhaps. I'm wondering how does like tipped employment come into this? Because I have had regularly several students who work as servers and they say I don't ever get a paycheck. So their employer pays them no paycheck because I guess theoretically their tips pay them, but I still find that strange if they have a minimum wage of $2.13, which is what it is in Tennessee. Because it seems like a real way for the employers never to pay payroll taxes, or really, I don't know if they call them employees, perhaps they do, but that just seems a real fishy, sketchy area for me.
Yeah, I mean, certainly those are state-by-state laws. In Massachusetts, we do have a service, what we call a service rate, is $2.63, provided that the employee makes up to the minimum wage in tips, then, but the worker still is entitled to the paycheck for the $2.63. So, I mean, in that case, it sounds like there's an issue going on there, but there is certainly a lot of violation there. And then there's this growing issue that we're seeing of more and more employers trying to classify their employees as eligible for the service rate because they may have a tip jar at the counter. Is this in Tennessee? You have this too, that you go to the local coffee shop and it says, you know, tips with a smiley face, and then that suddenly becomes, oh, that worker is a tipped worker. It's not quite how the law was intended to be, but nonetheless, we see that going on.
Yes, as I was in a restaurant in Nashville a few weeks back, and I noticed a tip worker doing the work should have been classified as a non-tip employee. They were bussing tables and they should be waiting on tables, and yet they're earning a tip wage. Obviously, if there's not a misclassification. In Massachusetts, how does your department deal with such misclassifications?
Well, again, that would be an enforcement matter for our Attorney General's office, not our state Department of Labor Standards, my department. But that would be a violation. There would be a violation of Mass General Law 149, where it's improper. If they're saying that the person doing the busing work, you said that the person doing the busing work is suddenly now being classified as a tipped employee, it would just be not legal under Mass law, and the Attorney General's office could take action, starting with essentially a wage complaint coming from that worker.
So in Massachusetts, are most of those actions by the district attorney or the attorney general would be initiated by, you'd have to have a complaint come in?
We always advise the workers to file a wage complaint, yes. But it does not have to be stemming from that. But again, that would be for a larger.
But it's reliant on complaints, there's not an investigatory agency.
No, there is. In fact, many of their investigations come from the task force.
Okay.
So you've got that balance between, handling the calls and the emails that come in. This is my situation, please help. And then you've got the larger scale investigations where that one, this is happening to me, please help. We might look into that and discover this is a massive corporate policy that's going on and have a larger issue.
It's been brought up before that there is this disjuncture and this fundamental issue between national policy and state policy. And Matt, you travel around the United States a lot, working at the state level, but you also interact with federal agencies and know some of the political landscape that addresses this issue in Washington. I wonder if you could give us a little bit of background about whether if there's any addressing of this, particularly since while we're looking at in a state like Tennessee with no income tax on wages, it's not such a big issue. Next door in Kentucky, misclassification amounts to, even though it's a smaller state, a lot of money because a lot of income tax at the state level is not collected. But at the federal level, it has to be hundreds of billions of dollars a year that's, or at minimum, might be more than that, that's not being collected. And so why are we not seeing more vigorous initiatives from the federal government? You talk about the insurance companies not doing things. I'm surprised that the federal government and the Department of Justice have not, and maybe the Congress have not done more on it.
It's a long, woeful story. We see the state action and the state enforcement as a laboratory for finding out what is working well and what isn't, and for upward pressure on the federal government. Now that seemed to have been happening. We had a flurry of bills being filed on the federal level, one by Senator Obama to amend the safe harbors in the tax code, and a number of other bills that would make failure to properly classify someone as an employee a violation of the Fair Labor Standards Act. So all that stuff was happening. In addition, Vice President Biden had his middle class task force where this was an issue. And for instance, a bill called the Fair Playing Field Act, which came out of that committee, was supported by that group was supported by Treasury. That bill came out. Then another thing happened. All right, okay, get technical here. A very good thing happened in the Affordable Care Act. People ask me all the time, well, we hear the IRS has these Black Hawk helicopters and the NSA, they know everything, so why don't they know about this? Well, there's a 1099 reporting is not universal. 1099 reporting is only required where the service recipient is not incorporated. So the ACA, in years where the Bush administration wanted to get rid of that loophole, so that the service recipient was a corporation, 1099 would be required. The Obama administration wanted it. The GAO has been recommending it for about 20 years that this change be made to the 1099 law. So it was put into the ACA and it passed. Now the problem was that Senator Caucus overstepped, and not only did it require payments for services, but if the payment was made purely to buy goods, like for instance, if you paid Staples $1,000 for an OPEX, you would have to report that to send out a 1099 for that. That was a bit of an overstep. Well, then something happened in 2010 elections, the backlash on the ACA, and we tried strenuously to fix that ACA provision. Just think about what that would have done. That would have given another data point to the IRS to make it easier for them to catch the bad guys. They do it in Canada, and they bring in $200 million more a year in revenue in Canada just because of that. And that's just for the construction industry. The ACA was everything. And Canada has a little bit more people than California. So just think about how much money that would be going in. But the 2010 elections happened. The administration lost its will looking at the election results to fight back against the attacks on that 1099 reform. And it was the very first thing stripped out of the ACA. And it was supported by the Obama administration and the Democrats and the Republicans because small businesses claimed that it would be way too burdensome. So I think at that point, the federal government, the Obama administration is saying to itself on a legislative level, this is too big, this is too tough on the legislative level. So we've seen things happen more on the administrative, regulatory level with the hiring of new people by the U.S. Department of Labor, funds. You may not know it, but if there's funds available to the states through the U.S. DOL to help you all help states battle this problem, there's grants available. So yeah, that's why. It's they got their the administration got whooped because of that ACA provision in the 2010 elections. Big setback. So the playing field is still in the states right now. Doesn't mean this is not going to come up in, for instance, tax reform. The other team is already mobilizing, and they're already saying back off on this issue because they see what's happening in the states. They see in Senator Lincoln, ex-Senator Blanche Lincoln is a spokesperson for one faction. They see what's happening in the states. They see the possibility of happening on the federal level, and they're bringing out the clarity. You can't do anything until there's clarity in the definition of employment. Okay. What about Mr. Nobles? What about Mr. Nobles? I mean, Mr. Nobles is pretty clear on what the law means. He's pretty clear on what he's doing, and people like him are very clear about what they're doing, and they're making suckers out of every single legitimate employer that pays his or her taxes in the country.
There you go. Any other questions? Comments?
Oh, the Labor Department's doing a survey on this U.S. DOL.
Well, it is exactly 11:30, which is our scheduled time to end this session on the minute. Bravo.